Agora eu tenho a honra de chamar ao palco o Kirchner. Ele é diretor executivo e diretor jurídico da Associação dos Práticos Americanos. O Sr. Kirchner foi advogado em Washington, D.C., especializado em direito marítimo desde a graduação em 78. Ele tem representado os práticos e os interesses da profissão perante o Congresso americano, agências federais, órgãos legislativos e administrativos estaduais e municipais e a Organização Marítima Internacional IMO. Ele falará aos presentes sobre a praticagem nos Estados Unidos. Por favor, Sr. Kirchner.
It's a great honor for me to be here and to be asked to join with these expert and important speakers. A few days ago, when I looked at the program, I noted a few things about today. Number one, I was in the last session of the day, but it's right after coffee break, so that's a good thing. Over my career, I've had to listen to talks by many attorneys, and they can be exhausting, and they're not much fun. So I'm glad that you've been caffeinated, and I hope that we can all get through this with a minimum amount of pain here. I also noted that that after me is going to be Hans Hermann Lukert, and I noted that the organizers apparently thought it was a good idea to put the two Germans together. And then finally, just so that you know, although my name is Kirchner, I am not going to give the Argentina report. I'm going to talk about the pilotage system in the U.S. There was a paper outside there which the organizers have put in a very nice cover. There's an article in there that's a law review article. It's written for lawyers, but I think you can get through it. You know, it's not that bad. I won't be going through that, but that's available to you if you want some more details. And because of the time that's involved here, I can only speak in generalities in some cases, and so I can't spend as much time as maybe I would have liked or think or thought is necessary to go through all the details of the U.S. piloting system, but the document is there. And there's also a one-page paper on the U.S. role and responsibility of a pilot that I may be referring to later on. So when we talk about the pilot system in the United States, there are two main points that I want to make. First is that pilotage in the United States is heavily regulated. And in fact, we have two layers of pilotage regulation. There's regulation by the federal government and, more importantly, regulation by our state governments. As you know, there are 50 states in the United States. 24 of those states have a coastline, and they have ocean-going ships that come in and out of those states. The second important feature of the pilotage system in the United States, and I think it's important for this group to understand, is that pilots in the United States are private citizens, but they have public responsibilities. And that gets back to what Captain Watson mentioned earlier today, that compulsory pilotage is navigation safety regulation. It's a public service. And that ties together these 2 points, that because it's a public service, it's entirely appropriate and proper for the government to heavily regulate that practice. So let's talk about the pilotage system. First, the state pilot system. In 1789, the first Congress of the new United States, one of the very first acts of the first Congress was the Lighthouse Act of 1789. In there, the new government took a look at the maritime activities of the country and decided which activities were going to be the responsibility of the federal government and which activities were going to be the responsibility of the state governments. As you might imagine, they dealt with lighthouses, and Congress at that time took a look at lighthouses and decided that that should be a federal responsibility. So they took over the operation of all the lighthouses in the country. In Section 4 of the Act, however, they got to pilotage, and they reached the opposite conclusion. They decided that until Congress should make further legislative provision, that pilotage should continue to be regulated by the states. And that decision was based on two things. First, by that time, the colonies had their own pilotage systems for at least 100 years. And those systems seemed to be working fine, and the new government had enough to do without getting into something that the states were already taking care of adequately. But secondly, and more importantly, Congress took a look at pilotage and determined, because of its nature, that it's best regulated at the local level. That because of the variations in conditions from port to port, that a national approach was not the way to go. That it would be better to keep the regulation at a lower level, at a more local level. So that created the state pilot system in 1789. It's been in existence ever since. It is today the predominant pilotage system in the United States. So when you're talking about the pilotage of international trade vessels, you're really talking about state pilots. These are individuals that have a license that's issued by a state government. As you'll note there, each of the 24 coastal states has its own pilotage statute, its own set of pilotage regulations. Typically, in 23 of those 24 states, the entity that's responsible for the pilot regulation is a pilot commission. The makeup, the responsibilities of the pilot commissions vary from state to state. The most popular or the most common model is a cross-sectional representation or membership of a commission. There will usually be an equal number of pilot users, ship operator interests, as well as pilots. There will be so-called public members. There might be environmental representatives. There are governmental officials. And so the important thing there is to have a cross-section of all the stakeholders in pilotage. In some states, under their statute, there are no pilots on the pilot commission. But in no state do pilots regulate themselves. There's no pilot commission in the United States in which a pilots comprise a majority of the membership. These pilot commissions in the United States are the competent pilotage authority, the CPA. So let's talk about the state pilot system. The essential, most fundamental job of a pilotage authority is to administer the compulsory pilotage requirement. If you distill what competent pilotage authorities do, that's what they do. That's in the form of a compact, of a deal that's made, that says to a ship operator, we're going to require you to take a licensed pilot. But in return, we will ensure, the government will ensure, that every ship that needs a pilot will get a pilot without delay and without discrimination. That pilot will be trained, competent, rested, able, and fully prepared to provide expert pilotage services. Not only that, the pilot will be supported by an operation that's got everything that a modern, efficient, safe pilotage operation should have. It should have first-class pilot boats, a dispatch system, a rotation system, equipment, PPUs, radios, whatever it takes, a quality administrative operation, everything that a first-class pilot operation needs. So every activity of a pilot commission can really be tied to that fundamental job there. So In the United States, a typical pilot commission will issue the pilot licenses. It will oversee training. It will enforce the compulsory pilotage requirement. And that's important because the pilot commission recognizes that it not only regulates pilots, it regulates pilotage. So it has to deal with the industry, with the shipping industry, with the ship operators. And so they regulate ship operators as well as pilots and make sure that ship operators comply with the pilotage requirement. The state will oversee the pilot rates. Every state with a pilotage system in the U.S. sets rates. It's not the subject of a private agreement between the pilot and the ship operators. Now, the rate setting process encourages pilots and ship operators to get together and reach agreement on rates when they can. But in the end, it's a public function, it's a governmental function, the pilotage rates or tariffs. There's oversight of operations. The pilot commissions want to ensure that the pilot operation is kept up to date. That's related to its function with rate setting. The job of setting rates is to not only ensure that the rates are fair and reasonable to the users, but that they produce sufficient revenues to pay the costs of the type of operation that the state determines they want and they need to protect their waters. So, in other words, rates should neither be too high nor too low. And whatever entity sets the rates, and in some states it's not the pilot commission, it's some other body. They have to balance those two items. And then finally, there is professional accountability. It's the oversight of pilot performance. If there is sufficient performance, if there are casualties that result from pilot error, if there's pilot misconduct, the pilot commission will review complaints about pilots, will investigate casualties, and will take action if necessary to respond to problems in pilot performance. So it's a comprehensive system, all part of that agreement or the deal that's made with the ship operators, that they're going to get a first-class pilot in return for their obligation to take the pilot. Now, I mentioned earlier, there is federal regulation. First, there is a federal licensing program. The U.S. Coast Guard issues federal pilot licenses. The standards for those licenses, however, are much lower than for a state license because the license serves a number of different purposes. But every state pilot in the United States, and that's about 1,200, also has a federal pilot license. And in that respect, the Federal Pilot License acts as a national minimum standard. There's a Great Lakes pilotage system. That's a niche operation. There are 32 pilots in the Great Lakes. Because of the international waters of the Great Lakes, that requires a federal approach. No state under the U.S. Constitution is able to enter into an agreements with a foreign government. So in order to have agreements with Canada on the operations on the Great Lakes, we have to have a federal agency that's in charge of the pilotage there. So there's a Great Lakes Pilotage Act of 1960. That's the date by which the seaway was expanded, and ocean-going vessels, fairly large at that time, ocean-going vessels could come into the Great Lakes, so there had to be a pilot system put in place there. It was modeled after the state system, however, with an office in the U.S. Department of Commerce at that time that was supposed to run the pilot system there along the lines of a state pilot system. So not only did the pilots have to have a federal pilot license, they had to have a registration, which required higher standards, additional training over and above the federal license. Those rates are set. For example, there are limits on the number of pilots It's got all the attributes of the state pilot system, although it's run a little bit differently. And then finally, under federal pilotage, there is an exemption from state regulation. That's for coastwise U.S. flag ship operations. And there aren't a lot of those. But those operations require only a federally licensed pilot. Now, most of those ships, most of those vessels, and a lot of it now are tank barges, ATVs, ITVs. They will take a state licensed pilot because the state licensed pilot also has a federal license. Let's talk about the role of the pilot. And Joe Angelo talked about this earlier this morning. This was an item of discussion between Intertanko and the American Pilots Association and IMPA when we began our discussion group. And the ship operators, the Intertanko people, wanted to know about the U.S. position on the role of the pilot. And in the packet that's out there's a one-page explanation of the role of the pilot and the respective responsibilities of pilots and masters under U.S. law. That contains the statement in there that the pilot is not a member of the bridge team. That statement has received a lot of attention since it was first adopted in 1997. There are a number of ship operators that are not happy with that statement. There are some pilots in other countries that aren't happy with it, and we've had to explain that. And the purpose of the statement was to get people to recognize that compulsory pilotage, at least in the United States, and in fact in a number of other countries, is a public service, and pilots are required to exercise independent judgment. And so that means sometimes they have to say no. If a ship wants to leave under conditions when it shouldn't leave, the pilot's got to say no. If the ship wants to do something that the pilot feels is unsafe, the pilot has to have the freedom to say no. He's not there simply to do what he's told by the shipmaster. Fortunately, the instances of that type of conflict are extremely rare, but they do happen. And state pilots are told that if they don't stand up and do what's necessary and practicable to defend the interests of the state, then they're going to get in trouble. And we have a number of cases in which that has occurred, where casualties have resulted clearly based on a decision by the shipmaster and a decision in which the pilot did not agree. And pilots have been disciplined for not standing up and doing more to try to assert the interests of the state there and prevent accidents. This is somewhat of a evolving concept too. It used to be said that the role of a pilot is to protect a ship from the dangers posed by a port. Well, today the role of a pilot is to protect the port from the dangers posed by the ship. And that's something that pilots are recognizing, and it's been an educational process for them. But a pilot's role and the expectation of the public is that the pilot will prevent accidents. Now, pilots have to balance that against their obligation to provide good service. And that's the unique thing about pilots, that they're in a position there where they feel very strongly about moving commerce. They are mariners. They're in a maritime tradition. They feel very responsible for the health and well-being of their port. They want to move ships, but in the back of all their decisions, there is that basic responsibility to prevent an accident if they can. So, if you look at that one-page explanation, you'll see how the explanation tried to reconcile those two things. And it said there the basic principles that navigation is a shared responsibility. between the pilot and the master and bridge crew. When we first drafted that in consultation with the ship operators in 1997, the ship operators were very happy to hear that. They thought that was a major concession by the pilots. We didn't think that. We thought it was clear that both the bridge crew and the pilots have to share responsibility, and they each have important roles to play in ship navigation. So they have to respect each other's roles, and they have to cooperate. The pilot directs the navigation of the vessel subject to the master's overall command. That's right out of case law in the U.S. From over 100 years. And so that's the real relationship of the master and the pilot. We try to avoid the term advisor to describe the pilot. I know that's part of the maritime lore. People have been saying that for years and years. People I respect a great deal will talk about master's orders and pilot's advice. As I said, we're not going to refute that, but we want to avoid that because that's somewhat misleading. A pilot's role is more than just giving advice. As I said, a state pilot is expected by his or her state to exercise independent professional judgment in the public interest. There are a number of features of the state pilot system, therefore, that seek to insulate the pilot, to protect the pilot from pressures that might compromise his safety judgment. We're asked often about competition, and I'm happy to report in the United States we have non-competitive pilotage. The primary action that helps that process is that each state, and the Great Lakes office, the Great Lakes Pilotage Office is the same way, limits the number of licenses that it issues. And Captain Watson talked earlier this morning about the objective to determine and to maintain the right number of pilots. There is no place in the United States where state pilots, and no place in the Great Lakes where Great Lakes pilots compete with each other for work. In the state of Connecticut, primarily in the waters of Long Island Sound, there are multiple pilot groups that operate within the same area. However, they are all required to participate in a joint rotation system. And the purpose of that, the objective of that, is to keep them from competing for business. So if they want to have multiple groups under the law of Connecticut, they're entitled to do that. But Connecticut wants to limit or prevent the ill effects of competition. And to create a system in which there's really no incentive to have multiple pilot groups. If they can't compete, if they can't get a bigger share of the business than another group, then there's no reason to maintain their own pilot boat operation, and to do things themselves. The economies of scale will give them an incentive to eventually to join together and to operate as a single unit. This situation is based on a specific determination that the states have made that economic regulation, rather than market forces, is the best way to maintain the public interest pilotage and protect navigation safety. The Florida statute that Captain Watson referenced this morning explains that. And the legislature of the state felt it was important to say right up front in the very first provision of their pilotage statute why they believe market forces should not control pilotage in that state. And it's a very good statement if you ever have a chance to look at it. Okay, where do pilots in the United States come from? And not other pilots. How are they trained? Well, each state has its own system. one of the drawbacks of having 24 state pilot systems is that it's sometimes somewhat of a task to explain things like this. Pilots, the qualifications and the selection process for new pilots is different from state to state, and there's a broad range of systems there. Some states, particularly those along the east coast of the United States, will take people with no maritime experience. They will take people who graduate from college with a degree in American history or art appreciation, and they will train them from the ground up. They will typically have a very long training program. In New York, it could be as much as 14 years to work all the way up to a full full first-class pilot. Other places require maritime service, and they typically, some places, for example, the Columbia River Bar pilots in the state of Oregon require 2 years experience as a master on a deep sea ship. And corresponding to that, they have a shorter training program. That's an interesting situation there on the Columbia River, where we have 2 pilot groups that operate side by side. The Columbia River Bar pilots are all former shipmasters from the deep sea. And they bring the ship across the bar, and as soon as they're inside, they turn the ship over to a Columbia River pilot. The Columbia River pilots all come off the local tug barge industry. So they're all tugboat people. So they come from a completely different background. And but both groups operate in the same state. They are licensed by the same pilot commission. Their training programs, because of the difference in where these pilots come from, are completely different. For the Columbia River pilots, it's a longer training program because they have to develop ship handling skills, which they don't have coming from the tugs. But they hand off the ships to each other. I would like to tell you that they respect each other greatly, but they each think that their system is best. And that is the same. That is a universal among the variations in the pilot groups and the pilot systems in the U.S. Every pilot group firmly believes that their system is the best. And the interesting thing about that is they're right. They have the best system for their conditions and their needs there. So over the years, the qualification requirements and the training programs have developed to produce the most suited people possible. So we always talk about it's not so important what goes into the system. It's important what comes out of the system. So that every system will produce at the end of the training program a pilot that is well trained, has the knowledge that's necessary for the piloting assignments in that area. And the states are encouraged to take an approach that is really focused on the local needs. So we always say that the variations among the state programs are not a weakness of the system, they're a great strength of the system. Each state has requirements for continuing training. The most common model there is a cycle. It's like a 3-year cycle or a 5-year cycle. That continuing training can be ship handling simulation, emergency simulation, man models, classroom instruction. We're setting up ECDIS training now for pilots, for example. So, and we've had a BRM training program since 1993. The American Pilots Association sets the standards for that training. And we have guidelines for what a BRM course for pilots should look like. And by the way, those guidelines are much different than the guidelines for a BRM course for ship's crews. Because for pilots, there's a different need there. Pilots encounter a different ship environment almost every time they climb aboard the ship. And so you don't want a pilot that develops a standardized routine. You want the pilot to be flexible. So the emphasis in a BRMP course is on the two A's, assess and adapt. So they are, and pilots have been doing this for hundreds of years. But the purpose of the course is to get the pilots to recognize how they assess the qualifications and the resources of the ship when they get there. If they see a first-rate ship with an engaged and very professional crew, then they're going to pilot in a different way than if they come aboard a ship and the shipmaster is in pajamas and flip-flops and doesn't seem to take an interest in what's going on. And pilots encounter those differences all the time. And so they have to change their practice to meet what they find on the ship. The recommendation on BRMP, by the way, is every 5 years. So we've been doing this since 1993. Some of the pilots have gone to 5 or 6 of BRMP courses during that period. They don't like them much anymore, but they still have to go to them. I'm also asked about the employment situation of pilots. What's their status? The state pilots are typically self-employed. They belong to an association for the purpose of sharing expenses and sharing the support services and to achieve economies of scale. And in that respect, they operate much like a law firm or a practice of doctors. These pilots are entrepreneurs. There's a large financial at-risk investment. They're not employees. They don't have a salary. In most places, they have to buy in to the group. Once they become a full pilot, they're required to pay for a share in the business. That's to recoup the capital infrastructure that's already there, because other pilots have paid for the pilot boats and the office and all those things. So they have a big investment in the pilot operation. In the United States, there's only one port. There's only one significant port, and that's Los Angeles, where pilots are municipal employees. Again, that's a niche type of situation. Los Angeles and the neighboring port of Long Beach are not part of the state pilot system. They don't have a state license there. In Long Beach, there's a pilot franchise that's given by the port to a company, a private company, the Jacobson Pilots, that's been there since the 1940s. And so they're different, but they're excellent pilots. We talk to them all the time. They have a first-rate operation, but they're just in a different system than the rest of the country. We talked about professional accountability. That's another part of the compact for government regulation, that in return for a ship operator being required to take a pilot, the ship operator needs to be assured that that pilot will be held accountable, that there's oversight. A state pilot on a ship that's involved in a marine casualty is going to be investigated, and if it's appropriate, there will be a license action that can be undertaken by either the state or the federal government, and the options there are the license can be revoked, it can be suspended. Some of the licensing authorities now are getting a little creative in coming up with measures like additional training, additional observation trips, things like that. But there is accountability there, and a pilot's career is on the line every time a pilot climbs aboard a ship. There are civil penalties and fines by both the state and the federal government, and those don't have to involve a ship casualty. If a pilot is guilty of negligence or misconduct or is charged with misconduct, there can be a fine involved. More and more, and this is the elephant in the room here, there's criminal prosecution. I don't have time to talk about that. But if there's, but the shorthand way of looking at that is if there's oil in the water or if there's a death, it is expected that there will be a criminal prosecution of somebody. And we've seen a prosecution of a pilot a few years ago. And then there are civil lawsuits. And this is a major concern. Pilots traditionally have not been sued in court in lawsuits that seek damages. There are a number of reasons for that. That's changing somewhat. Pilots are being sued now with slightly more frequency. To address that, there's a concept of a statutory limitation of liability. And in 10 of the 24 states, there is a statutory form of liability limitation. Even though that's only 10 of 24 states, those are primarily the states with large numbers of pilots. So it's well over 50% of the pilots operate in a place that has a limitation of liability system there. Those can take one of two forms. One is a cap on the amount of damages. It could be $1,000 in South Carolina or $5,000 in the state of Washington. It goes all the way up to $250,000 in the state of Alaska, which is a problem. That's way too high. It defeats the purpose of the limitation to make it that large. That's almost an incentive for people to sue a pilot. Under all of these systems, they don't protect the pilot for alleged gross negligence or willful misconduct. So whatever limitation is available, it's not available to a pilot that's found to be grossly negligent or willfully misconduct. There is another form of limitation of liability. That's kind of a complicated system. It's called a dual rate system. In return for a lower pilot rate, which is actually the pilot rate, a ship agrees to waive all claims against the pilot and to indemnify and hold harmless the pilot from claims by third parties. That's a system, for example, that's in place in San Francisco. That was employed in the case of Costco Busan, and the pilot was covered by that system. Liability limitation has been around for a while. It's accepted by states and in most places by the ship operators because it's economically efficient. There's no real insurance that can cover a pilot for the potential liability exposure that a pilot incurs every time he goes aboard a ship. So, given that exposure, either the cost of insurance, in which case is going to be astronomical, because the liability exposure will be several hundreds of millions of dollars relative to the pilot fee, is going to mean that the pilot rate is going to have to go sky high. Or the rate has to reflect the economic risk that the pilot is assuming every time he or she goes to work. Ships are already insured for pilot error, so it just makes more sense. It avoids double insurance for the pilot's liability to be limited. Okay, the U.S. system. It's not perfect. There's some problems with it, but it has been successful. It's been around for a long time. And we like to remind ourselves in the U.S. that there are great benefits to the system. First, it's a true user pays type of system. There's no government subsidy. The taxpayers are not responsible for paying the pilots. The cost of pilotage is borne by the users of the pilot service. However, it's the public that gets a great benefit from it. There are two layers of regulatory oversight. Sometimes that can be complicated, and they get in each other's way. But no pilot will fall through the cracks between the two layers of government regulation. Pilots are protected from economic pressures that may compromise safety. I mentioned earlier that the state system is designed to offer that protection. Pilots have a personal career and a financial stake in the success of the pilot operation in their port. That's because they're not employees. And what they earn, their income, is based on the work that they do. And they want their port to be successful. And there are financial rewards. And those financial rewards attract high-quality, motivated people. We don't like to talk about pilot income, but there's no disguising the fact that to be a pilot is to achieve the pinnacle of the mariner occupation or profession, and pilots are compensated accordingly. And then finally, it's a democratic process. It's transparent. People will say that democracy is not pretty, but most countries have decided that it's the way to go. So the pilot users have a say. They can petition the government. It's all out front there. There are no backroom deals. So that's the U.S. system. I'd be happy to answer questions if there's time, although I see that there isn't. But no? Okay. Okay, well, thank you very much. I appreciate it.